Time is 6:30. I'd like to call to order this special meeting of the Genoa Township Trustees. This is a zoning hearing. Today's date is July 30th, 2025. Roll call, Joe.
Trustee Vaughn.
Here.
Trustee Antonitz.
Here.
Trustee McMurray.
Here.
Also with us this evening is Zoning Director Joe Schaefer, Assistant Zoning Inspector Paul Benson, Attorney Mr. Peter Griggs, Chairman of the Zoning Commission David Leff. The purpose of tonight's meeting is to review the proposed omnibus bill zoning resolution revision. I'm just going to start this meeting by saying I have no preconceived idea on how we want to conduct this meeting, and I'm open to ideas.
I also don't have any preconceived notion on how to run this meeting.
Ditto. I wonder if just maybe the best approach is kind of just to
Page by page?
yeah,
Page
that's
by
what I
page.
think, page by page, and if
Oh.
there's something we need to talk about, we talk about it. If not, we move on.
Okay.
All right. Maybe it would be helpful, maybe not, for Joe to provide a brief summary of the revisions, additions on each page briefly, if possible. Let me start this out by saying would like Joe to clarify on the colored document, which was helpful. I want you to explain the difference between text that has been struck through indicates that the text has been removed from the document. And then the yellow highlight crossed out says, the highlighted in yellow represents existing text as being relocated as is with modifications. Can you explain the difference between that and text highlighted represents existing text that has been completely and permanently deleted from the document?
Yeah, so you have basically two levels of editing that's going on. So when I first craft the document, I'm just using track changes in Microsoft Word. So anything I change in Microsoft Word is just going to change it in red. If I delete something, even if I'm moving it elsewhere, if I'm deleting it from that spot, it's going to strike it through. And then when I type new text in or paste it in somewhere else, it's going to underline it.
Underlined.
So that's the first layer of editing that you see. And then what I did to create the color code document is I did not go back into Word and change any of that because it would have been just too cumbersome and time consuming to do it. So I found the easier path was to just open the PDF and use the highlight function in PDF and then just go page by page and color code it that way. But there's different ways. So some of the text might be struck through and being permanently deleted. That's color-coded in red. But some of that text is being just relocated out. It's being moved from its current spot into a different spot. That struck through text is showing up in yellow. So technically speaking, if it's struck through and in yellow, you can find that text elsewhere
It's been moved.
in the document.
Yeah, okay.
And then there's actually a third level of that where the text has been moved, but then also altered in some way. Some of it significant alterations, some of it probably rather insignificant alterations. But yeah, so there's that level of it too. But without having to go back and totally rework the entire document, I felt like that was probably the clearest way to try to convey all of that.
Okay.
All right.
So I guess, are we going to work from the clean copy or the red line copy? And the red line copy is the same page numbers as the color-coded copy. Obviously, I don't have the color codes here in front of me, but I know what's what,
I don't think
so.
that's going to be necessary for you.
So we want to work from the red line. I just want to make sure
I
I follow.
like the red line.
Yeah.
That's,
I have
that's
the
fine
red
with me,
line.
because then I can see what the old text says,
I
sometimes
got it.
says.
I actually have notes on
all
both of
three.
them. All three.
Okay.
All right, so I don't have,
Oh, we do need to officially call the meeting to order, though, and go through the exhibit list.
okay.
If you weren't planning on doing that, just a reminder, I guess.
The time is 6:35. I move to begin hearings on the proposed zoning omnibus resolution. Do I have a second?
Second.
Discussion?
Well, I don't know if you, sorry, I don't know if you necessarily need a motion, we just need to read through
Okay, well, I don't
the
have that.
script.
Right here, you had it, it was sitting on our, did you lose
It's
it?
buried there.
Yep.
Sorry.
Okay, I move to call the following hearing to order at 6:35 PM. Noted that the legal notice and exhibits were read at the previous meeting, and ask everyone who wished to speak to this matter to stand and be sworn in. Anybody? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. The following exhibits were either amended or updated. Exhibit G, all public comments received between November 12th, 2024 and July 30th, 2025. Exhibit H, staff executive summary. Executive I, color-coded exhibit of the proposed amendment. At this time, we'll entertain a staff report from Mr. Schaefer.
So I don't have anything to report other than what we essentially just
Got it.
discussed. I'm happy to answer any questions, talk about whatever you need me to talk about.
All right, since nobody from the public stood to be sworn in, I'm going to assume that there is no public comment. So we'll move on to reviewing the proposed omnibus. Anything on page 1 of concern?
You talking Article 1? Not, yeah.
Oh, I'm sorry, yeah, Article 1.
Okay. I have a comment on 102.01A, the very last sentence. I would like to add, well, I guess we can't, that's in black. But we can put this on our list. 102.01A. The very last sentence, I would like it to mirror the Ohio Revised Code and just add general welfare and morals to public health and safety. But if it's in black,
So that's an exception to
Okay.
the overall rule, because there you're dealing with surface mining. They have a really good lobby, so our authority is limited to only public health and safety. That's directly out of the statute,
okay,
so.
thank you.
Okay, anything else?
No.
Page or article, the only revision on this page of any significance is minor revisions to the medical marijuana, which I don't have any.
I have something on that. The 102.13, we only address medical, but with the passage of recreational, do we need to add any verbiage to that?
That's why I just added the or otherwise, because I felt like the law was probably going to continue to be in flux on that.
I just want to make sure we're covered.
I think I tried to capture all the RSC citations for recreational.
Correct, those are the correct citations.
I mean, we can add recreational, it doesn't matter.
Do you guys have a resolution outside of this that
Yes.
prohibits?
They have two, one for
Yeah.
medical and one for
So
recreational.
that's gonna control.
Okay,
Yeah.
okay.
Yeah. And we do note that just for the public's edification in the use table. I wrote down the resolution numbers. and that
Okay.
They're separate resolutions.
Okay, section 10, on the next page, section 102.15 deals with solar and wind farms. Just generally refers to the Ohio Revised Code. Any changes? It's just restructuring section 103, no real significant change other than restructuring it. And then under 104, interpretation, just a clarification on the intent of this resolution. I don't have any issues with any of that. I will say that I'm not sure I understand 104.04, and it looks like it should be in a law book. And I'll read it for clarification. Under the intent and purpose, subsections of this and all other articles within this resolution shall be read, understood, and construed as establishing the objectives, goals, and rationale for such article, as well as for the standards within said articles that follow such verbiage, but not as enforceable regulations. I have no idea what that means. Could you?
I can explain it, but first I'll ask
Okay.
Pete if he understands it, because if he doesn't, then I got it wrong.
Okay.
Yeah, no, I understand what you're saying.
Okay.
But I'm also an
So
attorney.
that's a good sign.
I'm used to reading law, so.
So, basically, some of the problems I've noticed in the past is when the public's looking at the resolution and trying to understand the code and understand the regulations, they often will get tripped up by the intent and purpose sections of these articles, and like, especially for the zoning districts, and try to treat those intents and purposes as enforceable standards. That's not what an intent and purpose section of a zoning resolution is. It's exactly what it says it is. It says, these are the reasons that the intent and purpose section is the justification for why all the regulations you're about to read in that district exist. It's sort of like a preamble to the document. For these reasons, think of it as, for these reasons, we're writing these subsequent regulations. The reasons aren't the enforceable zoning regulations. What comes after that section is. So what I tried to do in the document was better sort of structure it so the intent and purpose section is completely separate from all of the other regulations in the articles, so they aren't as easily conflated. And then also I put that standard in there just as clarification to anyone who's reading the document that, no, if you're reading the intent and purpose sections of those articles, those aren't the actual regulations, because intent and purpose sections are purposefully a little more loosey-goosey gray, because they're not the nuts and bolts of the zoning regulation. They're just sort of it's sort of like an in-between between the comp plan and the zoning regulation itself. So like, I'm gonna try to find an example of an intent and purpose, just
So
to sort of.
so in a nutshell, what I think it is your justification for establishing your standards, right? You typically hear the term, you gotta have some sort of governmental interest when you adopt regulations. That's your governmental interest. The concern could be that, let's say an application comes in before you and meets every single standard. And somehow you want to rely on an intent provision to say, even though you're meeting all the regulations that we've established, we're still not going, I'm not going to approve it. So I think that's the reason that this language is in there. And, you know, I would advise against doing that, right? I mean, that's problematic when you ultimately, when you get to court, if an applicant has met every single requirement and you're not relying on your own rules that you've established. So, I don't have a problem with it from a legal perspective, but if it gives you heartburn, take it out.
I mean, the basis behind it will still remain.
So-
We're just sort of putting it down in writing.
If you ask me,
I mean,
Pete, an application is before me, it meets every single requirement, can we deny it based upon the intent language? My answer would be no. Can't, right? So whether or not you want that in your zoning resolution, that's completely up to you.
okay. I mean, the fact that you need to explain it says a lot. Most people that use the zoning code, if you can't explain it as legal counsel, have no idea what this means. And I don't know, how do we as a board make changes?
Well, you can tell me you want that deleted.
Just delete it.
Um,
Just tell Joe that's one of the modifications that you want to make to this, and that modification would be a deletion of that section.
Yeah, my other goal was to just remind ourselves that that's how those intent and purpose sections are supposed to work. If the phrasing doesn't make sense, yeah, either we need to change it or just delete it. I think it has value, but like I said, if the board feels like it's more confusing than it is helpful, then we shouldn't have it.
I think it is, and I wouldn't, I don't see the need in it. If you don't understand it, what the purpose of it is. Unless it's protecting the township from liability, but I'm not sure that it is, and it doesn't really, for a layperson, explain what the purpose of it. So if you want to, if there is a possible way of
You want to see if? I'm
layman
sorry, go ahead.
terms language,
That's what I was just going to say.
Yeah, that's what I was gonna say. Is there a
Maybe.
way we could rework the language
I mean,
to
if you-
be a
yeah.
little bit more lay?
This is not an uncommon provision in a lot of codes. It may be worded differently, but I think, between the two of us, we could probably go back and.
We can
and
workshop it.
Workshop it
all
a
right,
little
let's
bit.
do that.
Yep.
Okay. Construction of language, just some clarification on headers. Explain a little bit about 10503.
Yep. So that's basically saying I can delegate any of the zoning and administration duties to subordinates that we hire, Paul Benson, Rafiq. Just because it says the zoning inspector shall, doesn't preclude me, shall issue zoning permits or whatever the language is, doesn't mean I can't delegate that authority to Paul Benson or Rafiq. Now, if there's a statute that says specifically it's the zoning inspector's job, solely to execute this task, then it's gonna be me. But I think even the revised code has language in there that the board may hire people to basically help me administer and assist me in that matter. So it's just sort of, I guess, a rewording of that ORC section to a degree.
Okay.
Again, not 100% necessary to be in there, but because sometimes I think there's been questions and commentary about what zoning inspector can and can't do and what they should be doing and not be doing. And I think there's sometimes a misperception that if this document doesn't say it, that Joe can't do it, and that's not entirely true. So sometimes I'm just trying to, well, if they want to see it in writing, we'll put it in writing kind of thing.
And why is it under section of construction of language and not under 114 administrative bodies and their duties?
I think it's how you're, I think its basis is how you're to construe the language, not necessarily not a duty in and of itself. But we can move it, yeah.
Yeah, I understand the purpose of it. I don't have a problem with it. I'm just don't understand why it's under construction of language.
Yeah, we absolutely can just move it somewhere else that you
Okay.
think makes more sense.
Yeah, I would agree. Move it.
So I'm just thinking of administrative bodies and duties where you describe your role, unless there's another place that I'm
In
missing.
114.
No, that's a good spot for it.
Yep,
Okay.
we can make it just 11403. And I'll just renumber accordingly. That's easy enough.
There's really just clarifications, nothing major on 107, 108 comprehensive plan. There is additional language, 10903. I don't know that there's any significant change in that.
No, and that's one of those sections. Does it 100% need to be in there? No, but is it a useful section if someone wants to try to get cute with us?
Yeah.
Yes.
Where's my color code? I got it. Thank you. Okay. So you're removing the entire section 110, buildings under construction. Can you just elaborate a little bit on that?
Yeah, we're just relocating some of that language to the section that talks about permits and that whole process. It always-
115.03D is where it's
Yeah.
moved to.
Yeah, I'm sorry, the color-coded version in the PDF, if you open the PDF, it's a whole bunch of notes that tells you where everything
Yeah.
went. But unfortunately, when I printed out the hard copy, none of those notes apparently print out. So,
Good.
but yeah,
Okay, it's just moved.
it's just restructuring. It was sort of orphaned where it was, and I just, from an administrative standpoint, would be more useful in a different location.
Same with 111. zoning permit,
Yeah, by and large.
yeah.
115.03A2.
So 112 is the role of trustees in the zoning, in regards to zoning. And there was concern that that was removed, but it wasn't removed, it was relocated, right?
I think there was concern that with this verbiage, we are
Limiting.
eliminating trustees or our authority. Can one of you address that?
Well, I guess, number one, I'll point out that language, like in 11202, I think was of specific concern. If you go to Article 2, Section, the opening salvo of current Section 02, a lot of that is the same language about the zoning resolution and the interpretation shall
Yeah.
first be presented to the zoning inspector. I'm not adding anything, that concept is not new to the document, that's already in the document. I may be cleaning up some of the language in there, as you can see in the color code of some of the changes, but the foundation of all of that language is already in the document.
Yeah. I just want to make that clear because it came to my attention that it looked like the role of township trustees was removed in the process, but it's not. Section 202 is just relocated to Section 112.
Correct, and I sort of was thinking, well, you're in Article 1, so you're above Article 2 because you're above the zoning commission and subsequently the BZA when it comes to appointments and administration of the zoning code, so. Again, we can move it back, it just, to me, seemed more sensible.
Okay, so the opening salvo for section, the previous 202 actually is
Becomes-
relocated to 11202.
Yeah, and then you can see in the color code, there was some tweaks to that.
Yeah.
But the fundamentals are all the same.
Okay, anything that on the? where are you?
No, I'm good.
Just as long as you're keeping up.
I'm keeping up.
Okay, section 113, no significant modification, just removal of higher revised code to ORC. Section 114, the zoning inspector. I don't see anything in this of concern.
Joe, can you explain in 114.01 the red sentence that starts with the execution of the duties specified herein shall include the inherent right of the zoning inspector to exercise discretion when necessary in limited situations and in the interest of the public? Can you explain why you put that in there?
Yeah, so essentially what it is try as we might, we're never gonna write a perfect zoning resolution. There's just always gonna be something that was unexpected, pops up, something will still be gray, you're never gonna get it right. That's why it's a living, breathing document, and we're always just trying to make it as good as we can. So basically, it's just saying, and we can change the word discretion to something else, maybe that's not the best word to use. But it's basically saying in those situations, it is my ministerial duty I'm gonna have to make those decisions, because no one else can. The board doesn't have the administrative authority, it doesn't go to the zoning commission, it's not something that goes to the Board of Zoning Appeals, there's only one person left who can make that decision. So, again, it's sort of just putting down in writing what is already the case, and because of some of the commentary we've received and apparently some confusion, we're just saying, no, here it is in writing, right here where it says he can do this.
Joe, could you give us an example of maybe where that's happened in the past? Like a case?
Yeah, I'm trying to think, I mean,
Well, any any act that the zoning department undertakes, whether it's issuing or denying a permit or sending a notice of zoning violation, those are official acts of the zoning department. And with that comes, consistent with the statute, comes the responsibility to interpret the law, the provisions of our code, and then make a determination. And like I explained last time, the process then is it gives the resident or an adjoining property owner the ability to agree or disagree with that determination and appeal it to the Board of Zoning Appeals. So, this is just basically a reiteration of the day-to-day operations of the department that Joe and the staff undertake. But yeah, it could be a permit. Look, agricultural exemption is one of the more difficult things to determine whether it's appropriate in a particular case, and you have to kind of review the facts, and sometimes you have to interpret, and you have to make a decision. And I think that's all this section really do, is reflecting what the staff does on a day-to-day basis.
I can provide an example if you want one.
Sure.
Go for it.
So I won't name names. I got an inquiry from a owner of a property here who does not reside, owner of a business here, but does not reside in the township, about wanting to occasionally land their helicopter here. They want to visit property they have interest in, they want to land the helicopter here. And not even on the site. Originally it was, I want to land it nearby, and then I guess, I don't know how they were going to get over, I don't know if they're going to walk or what. But they want to land their helicopter here. We don't really have the words helicopter in the zoning code. We have one provision in Article 6 of the rural residential that says private landing fields for aircraft for use by the owner of the property and their guests, provided that no commercial activities take place on said premises, are regulated by the following. And there's about a couple standards there. And that falls under the conditional use section of Article 6. So I have to now figure out, does that mean you can land a helicopter in Genoa Township? That's the kind of inherent. Now, I talked to the prosecutor's office. I gave them my 2 cents of it. They gave me some feedback. They were in agreement, actually, with how I was reading it. And we proceeded accordingly. And I informed the property owner of how that code section was going to be interpreted. I don't want to get too much in the details on that. But, and that's a recent example. That's happened in the last few months. So there are just, again, going to be things that come up, and I'm going to have to look at the verbiage and determine, and sometimes it's working with legal and saying, what's in the best interest of Genoa? What's the spirit and intent of the resolution? But also, what is your legal advice on how I handle this situation? So they don't make the final decision, but I obviously put a lot of weight and stock into whatever they're telling me. So that's an example.
That's why the zoning inspector is the least liked person in the township.
I would suggest if we could, I think if we could soften this a little bit, and I would suggest is execution of the duties specified herein shall include the ability of the zoning inspector to exercise discretion when necessary in limited situations.
Yeah,
The inherent right just,
it sounds aggressive, doesn't
Yeah.
it? Yep. And Pete, are you okay with the word discretion there? I know we really don't use that word, but.
Yeah, I think it's fine.
Okay,
I don't have an issue with that. That's what you do.
okay.
any suggestions? Good?
Yeah, I'm good there.
Yeah, I like ability.
Let's see. Let's elaborate a little bit on 114J.
That's essentially what we talked about. It's just more specific about, I make the final determination when it comes to interpreting the code, and unless it's obviously a matter that comes before you or the commission or the BZA. And that anything I do in terms of making an official zoning determination is subject to appeal to the BZA. They're the check on my power. And that's, again, just sort of reciting the ORC in just a different way.
Any input on that?
No, I'm good.
Okay. Section 115, zoning permits and certificates of compliance. You've added C, D, E, and F. Can you elaborate a little bit on those?
Yeah, C is just a clarification of what we already, it's actually just writing down existing practice, codifying it. D just refers you to new language in 117, so it's just
Yep.
a redirect as a reference
Yep.
point. E is, again, I don't have the color code in front of me. I can't remember if that's new language or relocated language, but again, that's codifying, I think, pretty
Green.
standard practice.
It's green.
It's green, so that's newly added language, but I think it's there to help in those situations where we might have, and Pete's probably dealt with this, the removal and replacement of buildings. We've also had situations where people have tried to get a little cute with, like, well, if I tear down this much of the structure, do I still have to comply, am I still grandfathered in, or comply with the setbacks, or how you're gonna treat it? And so it's just setting the ground rules and clarifying, no, and this is how we're gonna handle these situations. And then F, again, it sort of goes in line with the interpretation stuff we're talking about. We've tried to make it very clear, or as clear as we can in this document, when or when you don't require a zoning permit, but there's going to be situations where it still may be gray. Again, under the interpretation abilities that I have the authority to make that final determination of whether or not you're going to have to apply for a zoning permit for any given project. Which, again, we already do that. It's just writing it down. And I guess E is also a tie-in to sort of remind people that if you are in that situation, you need to go and now look at Article 25, which talks more in-depthly about nonconformities. So some of it is trying to make it, I know it doesn't look like it's user-friendly, but for someone who's interested in that section, it is user-friendly because now they know, oh, there's a whole nother article in the zoning resolution I need to look at that deals with this subject, and it tells them where to go.
So we never had this 50% provision before?
I don't believe so.
And where did the 50% come from?
I think that's the pretty standard.
A lot of times, that percentage you'll find in a non-conforming section where at some point we have to draw a line to say, and you're gonna have to rebuild, and you're gonna have to rebuild in conformance with the current regulations. You lose your non-conforming status.
Mm-hmm.
Typically, it's around 50%. I've seen 75, but 50 is probably more common. My guess is that's where Joe probably pulled that percentage from.
Yeah, some of this language just comes from researching other codes. The county code, I mean, frankly, you Google stuff and you look at stuff and you read stuff and you determine. I look at a lot of the townships Pete works for and said, well, Pete probably wrote that language and it probably is good language.
Okay, my concern is, I'm not opposed to this, but the enforcement part of it is a little bit troublesome. I don't want this code to get so convoluted that we need additional staff to enforce it. So, for example, who measures the 50% and how do you catch it to enforce it?
Well, a lot of that information is going to be available online. It's public record. It's either going to be on the auditor's website as to how big that building is. We can measure it on the aerial imagery as to how big the building is. And then they're going to have to apply for the permit and tell us how big the new building is. And they're going to have to give us drawings that show, all right, we're removing this, but replacing it with this. I mean, we're going to be able to match it up. And the building permit records will also, they'll have to pull the building permit. Some of it will get caught at that stage and then boomerang back to us when someone's doing that. I mean, we don't see this situation a ton. Usually you get these are either very old tear downs, which we don't frankly have a lot of, relatively speaking, or like house fires, house gets struck by lightning, those types of rare situations. But you do have builders sometimes want to try to occasionally get cute, and they'll be like, well, I'll tear down only so much of it because I don't want to lose my protected, my grandfathered setback that would not be permitted today, and so it's just trying to make those rules clear to try to avoid some of that type of behavior we see. Again, we don't see a lot of that behavior either. I can't say it's a problem, but I don't want it to become a problem.
All right, I'm going to put an asterisk by that one. Come back to that later. 11502, application for zoning permit. I don't have any issues with that.
The only thing I said here, applications that fail to include all required components may be, did we want to leave it as maybe or will be? Or are we just, like, if it's a minor,
That's
but
why
like
it's may.
substantive, you would,
And
okay,
again, that's where the interpretation and discretion comes in of,
okay.
do you really want to deny an application because they forgot to write the date of the application on it?
Okay,
No, we don't
If
wanna
you
do
make it shall, technically speaking, if I was
You would have
enforcing the
to.
law, I would have to.
yeah.
I don't think that makes sense. And they're gonna come and complain to you or the BZA about it, so let's just not create that situation, in my opinion.
that. Okay, any other comments? Uh, 115, processing of zoning permits. There's two new provisions, right? Or they relocated?
That's
Those are
relocated language
relocated,
that's been
yeah,
modified.
relocated.
And again, that was just for the ease of administration. When we're citing things to people or telling them where to find stuff.
Can we review the verbiage in 115.03A, the 1 and 2?
Yeah, I'm looking at it now.
I just want to make sure we're not giving developers too much time to develop.
An important caveat to that is
What's considered construction?
well,
Yeah.
the majority of permits this is talking about, you're not talking about a developer. You're talking about your pool or your shed or your deck or your brand new home. Like, it might be a builder. And I think sometimes when we look at zoning, we look at it through that lens of the developer.
Yeah.
But by and large, day to day, this document largely is administered to your own residents.
Okay.
And which also means a good chunk of this document will never apply to your residents. I know people get freaked out about the length,
Yeah.
but there is so much of this that your residents will never even need to pay mind to because they're not a developer. So,
That's very typical, 1 year. I mean,
Okay.
I've seen some people go 6 months, but that tends to.
we were 6 and it was a problem.
Okay.
It's just not realistic.
Yeah.
Especially when you're having people build 10,000 square foot homes. That's just not realistic.
A lot of times it creates more paperwork or more effort on staff because people are coming in and either A, getting a new permit or asking for an extension.
They're asking for an extension, they usually have a good reason, and I'm just issuing it. So if I'm just constantly doing that, then maybe we
So
just need to reflect the
in this
reality.
document, we're changing it from 6 months to a year?
No, I think it's a year right now. We changed that a while ago.
Yeah.
Okay, all right.
And again, I know we've had this discussion, I think I even had it on the zoning commission, about what designates start of construction. And do we define that anywhere in this document? Can they go out there and dig a hole in the ground? Is that considered a start of construction?
We don't define what construction is. We'd probably just rely on the dictionary definition, and then if I still was not sure, I'd probably call Pete. Here's the conditions, and he'd probably tell me, yeah, I think you got something, or no, I think you're gonna have to let this one go. I'm not sure you really could adequately define
Yeah.
construction.
Yeah.
Because there's just so many different types of projects. Usually if there's a big yellow machine and they're moving dirt, digging a hole, you know, I see wood on the property, metal on the property, building supplies, I think construction started.
Okay, any other concerns with 11503?
I think just, what, I can't even read this section. I guess it's D2, where we talk about the ground story framework. There's been feedback that this should be moved or removed.
No, I'm sorry, and the color code, which color is that? Is that green?
I'm not sure. It's
It is
purple.
So that means it's language that's been relocated, but I
Oh,
did
I'm
modify.
sorry, yeah, it did, but it was moved from 110.
Yep.
Yeah, I thought it was kind of odd and it didn't fit in this section.
I mean, we can move it under 11503 and make it number 3 over there. Yeah, I don't disagree that it could go somewhere else.
Yeah, it does kind of make sense that it would go with all the other stuff that has a
Under A.
timeline.
Yeah, so you want me to just move it make
A.
it a 11503.3?
Yeah.
Yep. Easy enough.
Anything under 11504, 1 and 2 with the zoning inspector authority for certificate of zoning compliance?
I don't have anything.
Nothing of significance in 06, 07, 116, nothing of any significance. Um, 11701. So 11701 is a whole new section.
Yes.
And can you elaborate on what the need is for that?
We are just trying to put in writing, again, a lot of this is existing practice. Just trying to make it easier for people to understand what doesn't
don't you?
require a zoning permit. Not only just for the public, but also for the person administrating the document, because I know the longstanding practices and theories and how things have been done here, you know, Susan taught me well. But at some point, that institutional knowledge might get lost. So it's just there, putting in writing. Do we have to have it? No. Do I think it's helpful? I think so, unless Pete sees any kind of liability issue with it, but he's shrugging there, so.
No, I appreciate it, actually. I think it's helpful for both parties in this. Right? Anybody else?
I'm good.
All right, we're through Article 1. Good progress. 15 minutes. No, it wasn't 50. 45.
Mm-hmm.
Article 2, responsibilities of the zoning commission. I don't think there is anything significant just stating that they have the power and authority granted by the revised code. I don't have any concerns with any of these. Which brings me to 202, which was completely removed, which I had as a note, but it's actually relocated, right?
Yes, to 112
Right. Okay.
in Article 1, yep.
Brings us to Article 3, responsibility of the Board of Zoning Appeals.
I don't have anything.
Anything either.
in
For
Article
zoning- Zoning appeals. Let's see. Conditional use provisions. You have relocated significant part of this. To where do we put that?
Yes, so conditional uses by and large in terms of regulations surrounding them are all now Article 7.
Okay.
To me, how we were dealing with conditional uses was a glaring weakness. Try to describe it. Move to Article 17, and this was a glaring weakness of the document, and I've tried to really significantly up our game here, improve how we're doing things. I can elaborate on what I meant by glaring weakness. I realize that's sort of strong
Sure.
language.
Yeah, please.
So we had a lot of uses that we were saying were conditional use, but there was no conditional use standard specific to that use. Occasionally, you'd have a couple provisions here and there in the districts, but it was by and large, oh, it's a conditional use. Well, okay, but what does that mean for the BZA? So if there weren't standards actually in the document, like we have standards for like accessory dwellings, because since I've been here, we've written them in as conditional uses, and I wrote in specific standards for them. But there's a lot of other uses that weren't, or probably should be, that didn't have standards. So all the BZA had to go by was these very vague conditional use review standards, which were not tailored to an individual use. They were just very high-level thinking things. A conditional use standard should not be a high-level thinking thing. It should basically almost be a black and white. Do you meet the standard? Do you not meet the standard? So that's why we've gone through Article 17 and listed every conceivable use I could think of and tried to develop reasonable standards for them, whether they be conditional use standards or standards we want to apply as part of a plan development.
Okay.
But the glaring weakness was not having standards for a lot of those uses.
Other than that, there really isn't any other significant changes to section, Article 3.
I'm good.
All right, Article 4, definitions. I'll be honest with you, I didn't put a lot of effort into definitions. Are there any concerns in here with any of the definitions?
I don't know that I have concerns with definitions.
I just asked, where did they all come from? The new ones?
Yeah, they're sort of from all over the place. I wish I would have tracked, okay, this is where I got this, this is where I got this, this is where I got this, but I didn't. A lot of it is referencing other codes. A lot of times when I was trying to do amendments, you go to what you know, right? So as some of you know, I used to work in Cranberry Township, Pennsylvania, Butler County, for 5 years before I came here. Cranberry is a little larger than Genoa, probably over 30,000 people, but a lot more non-residential development. And they've been growing for quite some time. So to me, they had a very good code. I administered that code for 5 years. It worked. So a lot of times I leaned back and would go to their code. Now, did everything they have fit, work, make sense for us? No. But that's just an example. I would go to them. Like I said, I went to a lot of the townships that I knew Pete worked with, looked at their stuff. I look at county, the county code for definitions, or, you know, the surrounding communities, what are they doing, Westerville, kind of thing. And sometimes it really is just Google. And sometimes you can find, you know, academic papers, zoning papers, even if it's from another state, the use is essentially the same, or the term is essentially the same. So it's just pulling it from all of those different sources. And were there times I had to sort of sit down and just say, what is this? And try to just come up with something? Yeah, that happened too.
In the letter C, I put construction definition needed. I did not see a definition for construction. And I know you had said we didn't really have a definition for construction or like the start of construction, but that's just one that I noticed was missing that I felt maybe we should have.
Yeah, we can take a look at it. We'll
Yeah.
take a stab at it.
Yeah, why don't we do some research
I
and
think
see
I
if
have
we
some,
can.
I know of a couple codes that.
Okay.
That's a good
To
point.
define that?
I was struggling with that one, so that's why I didn't put it in there. But
Okay, okay.
yeah, we got something we can
This
use.
one has always been a stickler, you know, for as long as I've been here, this building height issue, and I see you've relocated it. So I'm not gonna get into it now, but when we get to it, we can have that discussion about the definition of a building height.
Yep.
I suspect that it still needs to be a definition, no?
Oh, it's in there. It just got
It's
relocated.
here, yeah.
It's, all of the height-related definitions just got consolidated under the term
The word height?
height.
Okay.
Oh, yeah, there it is.
And there's sub-definitions for building heights, sign heights, you know,
Okay,
structure,
that's
solar,
fine.
all that fun stuff.
In the Fs, I put definition of foundation and footer needed.
I think they're pretty standard construction terms. I'm not sure there'd be a lot of confusion. I mean, Pete, you know if anyone who defines those terms?
No, but I think it would be easy to put something in there if that's.
Yeah, I agree.
Yeah, not a big deal.
Yeah, if we're using it in the code, then we should define
Define
what
what
a
it
foundation
means,
is.
yeah.
I think a footer is kind of self-explanatory, but a foundation might not be.
Sure.
But I'm all in favor of having more than less.
Just have a general question for Pete. We have some uses defined that I don't think our residents would care to have in the township. Can we outright say, no, we won't allow this? You're smiling. Anywhere?
Depends on what it is, to be quite honest with you.
Okay, okay.
You know, very common question is, can we ban adult-oriented businesses? And the Supreme Court has said absolutely not.
Okay.
They're subject to the First Amendment. But they kind of have for some reason, a special classification. I think there's other ways. You know, I'm doing a lot of work in Lincoln County, and some of the townships are concerned about data centers, right? So do you write code that says no data centers? Or do you establish standards that no data center would want to come there? So it's kind of a delicate balance, and I hate to give just a flat-out answer, yes, you can, because I really think it depends upon the particular use. But if there's a particular uses that you want us to take a look at, either A, make it more difficult to locate, or B, look at potentially excluding them. I think we can. I just don't want to give you a carte, you know, a
Carte blanche.
simple yes or
Yep.
no, because that's just not the way it works.
Okay.
Sorry for the long answer.
No,
but
that's,
yeah.
that's helpful.
If I may, just briefly. So philosophically, I land on the latter part of that statement. I find it better to allow everything, but then just have a lot of standards for them. And you don't want to write standards that you know no one can meet, because the courts will see right through that attempt. But you write standards that they're not going to be happy about meeting, and especially if they start to pile up, they'll say, no, we'll find somewhere else to go. We can find some other community that doesn't, you know, no offense, but sometimes when you have low standards, that probably makes the developer say, this community knows what they're doing, and it's going to be hard and long, and I don't want to deal with that. They're going to go look for another community that doesn't have those standards, and they think they're going to have an easier time. So in some ways, it's actually good to have them, because it's self.
Like I said, most of the clients in Lincoln County that don't want the data centers, they're looking at building size. It's the same thing with like big box, right? You allow retail, but we don't want the big box, so we're gonna say any retail has to be limited to this size. So that's typically what most people will do, other than simply calling out, you know, no data or whatever the case may be.
And that's what Article 17 is all about.
Okay.
So my guess is most, if not all of those uses you are concerned about being objectionable are in there and have standards. Now, we can elaborate on those standards as much as you want, because it's all new text for the most
Yeah.
part. So,
Yeah, that's where there's going to be a long discussion.
yes.
I'm just curious why you're asking this under definition.
Just because I know that the definitions are coming in the next, or well, wherever we allow them is in the next section. So, yeah. Because the other reason was, do we just get rid of the definition? You know what I mean? It was many reasons for my question.
Not to allow it anywhere, you would still want to define
You would
the
still
term.
want to define it? Got it.
I don't know that
All
the
right.
definition.
Religious establishment,
Mhm.
the words "and the like" were added at the very end of that, and I just wondered what that
Yep,
meant.
sorry, I got to catch up here real
Yeah,
quick.
no, sorry.
And the like, that's one of those
And the
great,
like.
that's one of those great terms we put in the code sometimes to help us out. Again, generally speaking, we use that term because we just can't think of every possible scenario.
Okay,
And so when you see and the like, you can sort of make an argument of, okay, I didn't specifically list this, but we all know this is
this would
essentially the
fall
same
under that.
thing.
So-
Okay.
And I think also it has a lot to do with RLUIPA, the federal law RLUIPA, and what the courts consider to be a religious use
Okay.
is pretty amazing. Like ball fields have been deemed to be a religious use, daycares, and you can go on down the list. So I think that's just a reflection of probably that.
Okay, thank you. That's all I have on definitions.
There was a issue that, about the definition of average grade. Right.
We use that in determining the height, but I don't know that we define average grade. As part of the
I
concern.
believe that's correct. If it's not capitalized, then we don't define it.
Well, I
Oh,
think
is
it
in there?
is,
It
it
is
is
under
grade?
defined.
Ah, it's under grade.
It is
There it
defined,
is.
but I think there were
Comma,
questions
average.
on the definition.
Mhm.
That it should be measured from the front of the home versus using average grade.
Well, I think it says the average grade in front of the home.
Yeah, when we apply it to the height definition, average grade is just the average grade,
Okay.
regardless of what side of the building you're on. It's when you apply it to the height definition, that's where it mentions you're measuring it on the front of the home.
Yep, I see it.
But there is not a definition of average grade.
Yeah, but I think it
Yeah,
is.
sorry,
It's at the
Grade,
top.
comma, average.
Right.
Go to
Oh,
G.
okay.
Yep.
That was not my doing, I think that was already established that way. And I didn't move it. We can move it if you want it under A.
I don't have a preference. as
No,
long as
I
it's in
don't
there.
either. Mm.
Oh, there is clarification, because this is not correct. And this is the use of the foundation in here, because it shall be assumed to be 8 inches below the top of the foundation, but the foundation is the footer, unless it's slab on grade.
Mhm.
So that needs to be clarified.
So what would the wording we need to there then be?
I mean, for me personally, I think it'd be easier to measure it from finished floor of the first floor. And then there's no discretion about, and maybe it's 2 foot below finished floor. You can't use foundation because the foundation could be buried. If it has a basement, then the basement is the foundation.
I can look into that. I did not come up with that standard myself.
I understand.
So,
I understand. but
I would
think-
have to look at where that came from, and we can workshop that.
Absolutely.
All right, any other items under definition? No?
I don't have any more.
Yeah, I'm good.
Okay, section 5 is establishment of districts and map and uses.
I don't.
I don't have anything. Except the chart, right? Is the
Yeah.
chart
Next is
The
chart.
chart
Yeah.
is helpful, and I think appreciate the fact that it actually condenses the size of our zoning code by combining it all into a chart instead of having it in each section. Right?
I would hope so.
Yeah.
But it's always tricky when you do this because some people are coming to the code saying, I know exactly the use I want, I just need to know which district it fits
Yeah.
in. Other people are coming at it from completely the opposite of, I've just got this piece of property in this zoning district, or there's a zoning district I want, what uses can I do with it? So you're never gonna 100% appease both approaches. But again, this is the Cranberry way of doing things, admittedly. It worked very well, and I agree. I think it will shorten the document because we're not having to repeat all of these uses. There was also an inquiry at one point of, well, could you copy leave this here, but then also copy this in each one of the articles? I've always been hesitant to do that because that creates a situation where you amend the document later and you remember to fix it in one place, but not
Yeah,
another.
it's
And I
housed in
can,
too many.
and over the years, prior to my time, I can point to areas in this document where I know that happened, where they changed something and they forgot to do change.
Yeah.
Because it's like you'll have two sections and they'll be very similar but worded slightly differently. And you know one's newer than the other one, and you're like, they remembered to change it there, but they forgot to change it there.
I wonder if we could make, and I don't know enough about the technology that potentially could be behind this, but something that would almost be not a searchable document, but some type of tool you could use. I don't know. I don't know what that would look
I
like.
mean, we could go,
Like if you could put in, what kind of zoning district are you looking for? What kind of use? And if it could.
we
I
could
don't-
always do a user guide. 'Cause
Yeah,
that wouldn't necessarily be a zoning resolution document, just sort of like a,
like a tool. I'm just thinking of another tool to trying to make this more consumable for the user. I think this chart is a step in the right direction, but is there a way almost to not digitize it, but almost
So I guess I'm
AI
trying-
it?
It's almost like AI for zoning resolutions, right?
Yes, like you could create an agent that would go out and the agent would go and look at this document and you could say, this is what I'm looking for, and it could go in and pull it and say,
Yeah.
here it is.
Now, I will say most people in the fields are gonna be used to seeing a table like this.
Yeah.
And they're gonna know how to navigate it.
Yeah.
Any builder, engineer, this is what they're used to looking at. The building code has this all over the place.
Definitely. I will say this, that I have seen in electronic versions of code where it's a drawdown, where you just scale down in the actual document. I won't be able to do it in paper copy, but it condenses the electronic copy, so, you know what I'm saying?
Yeah, you have the ability, well, I have the ability to do that in PDF. It's just, do the work, we can do it.
Yeah.
Eventually, if this were to be adopted, like, there'll be in the PDF, we'll have it so like you can jump to chapters. We'll have those all on like in the margin where you jump to chapters. But yeah, we actually absolutely can put areas where, on this table, I could hyperlink to the SR article, and then if you click on that, it automatically jumps there.
Yeah,
That's what I've seen.
yeah.
We can put that in, we can build that in. And the wonderful thing about that is that's not really a zoning amendment, so I can just continue to work
That's a
on
user
that and
tool.
do that and just
Yeah.
upload a new version every time, because it's time consuming to do all those jumps. But I don't have to do them all at once. I can just sort of piecemeal it and just upload it as I continue to work on it. Also, on the on the website, if you're looking at this, where we post the resolution, Paul, can you actually pull it up real quick? I just want to show them how it looks on the website, how we post the resolution by article. So just go to our website, the zoning page, and scroll down to zoning resolution, over there on the right. Yep. So if you can see, if you scroll up a little bit, Paul, there's a link to the entire document where you can get all 300, 400 pages. But then if you scroll down, we do also break them up and post them by article.
Yeah.
I use that a lot when I'm like emailing residents. They'll want to like, what's the standards for pool? Well, I'm not going to email them
Yeah.
the link to 300 pages. I'm going to hyperlink article. Yep, Paul's doing it right now. I'm going to copy the link to Article 17 and say, in this PDF, go to section 17, whatever it is. That's where you find the swimming pool regulations.
Okay.
But in the full document, yeah, absolutely, we can do all sorts of jumping. I'll learn a new skill.
All right, so that gets us to Article 6, so we're getting into the actual districts. And I'm sorry.
Sorry, I found something. And this question is for Pete. For the short-term rental, I know we've added short-term rental verbiage. With the legislation that was proposed at the state level, with what we have in here, will we be okay if legislation goes through? Right. Well, if they say townships can't ban Airbnb short-term rentals, but you're grandfathered in, right, if you already have stuff in place? Okay.
through, because I municipally absolutely hates it as well, OTA. And, so, yeah, so, the initial iteration of that legislation basically said it's hands-off. You have to treat it like you would any other single-family dwelling. I think the more recent one is to allow us to regulate, not prohibit, but regulate. So unless something gets added or changed, I think you're okay.
Okay.
Because that's what you're doing, you're regulating, not prohibiting. So,
Okay.
but my understanding is, I'm not sure that's gonna, go anywhere.
All right.
That was one of the reasons for sort of, at the end, we were holding up a little bit because we were going to see what sort of happened there. And then I think we ultimately made the determination of who knows when, if ever, that legislation was going to happen or what it was going to be.
Yeah.
So we just sort of came to the conclusion, we're going to just march ahead and regulate them. And if the state says eventually we have to do something differently, we will cross that bridge if we come to it.
I think this is the third time it's been introduced, so, yeah.
If they outright say you can't regulate them, then we just ignore these sections.
Right.
Because we know they're not applicable, and eventually we'll remove them.
Okay.
You okay with that?
Yeah. Thank you.
Okay. Trustee McMurray, you have any issues with the table
No,
as
I
it
think it's a
stands?
good tool.
Okay, rural residential. Now this section is relatively small. Does any of the trustees have any opposition of Joe going through these changes in summary? Because if you remove the uses that has been moved to a table, you've removed section 602, 603, 604, 605, there really isn't a lot left on here, since that's all been moved to the chart. Unless you have any specific concerns over any of the other items in 6.
And I think we addressed this, Joe, but it was mentioned that we should add stipulations for drainage in the rural residential portion, just like the PRD. Can you address that?
Yeah, so I talked to Pete about that. We used to have stuff about drainage in here, and we actually removed it a few years ago. So I have long taken the strong position that zoning is not engineering. Drainage is an engineering matter. The statute, in my opinion, the revised code is very clear that drainage is a county matter. It's their job to regulate. There's nothing in the zoning enabling language that mentions drainage. So I've always been ardent that zoning should not be used to fill in the gaps created by the legislation. I candidly get frustrated because I think sometimes there are people told, well, tell your township to put drainage language in their zoning code. And I've tried to tell that agency that tells people that, please stop telling people that we're not going to do it. I don't think we can do it. Zoning was not created to just fill it, just because the state legislature did not give you the tools you need to deal with it, does now make it township zoning's problem. To me, that's a problem the State House needs to address. Also, I'm not an engineer. I don't have a degree. The most I know about drainage is water flows downhill.
And other stuff.
Yeah. So, I mean, I don't mean to be flippant, but I am, because if I go into court trying to like argue that I'm some drainage expert and cite someone, a good defense attorney is gonna run me out. The first question they're gonna ask is, where's your PE?
Yeah.
I don't have one.
So this is actually a very hot topic in Franklin County right now, and a lot of the townships are removing drainage because it's the engineer's job, you know, stormwater management, and so it's created a lot of problems in Franklin County. Like I said, I think three or four of the townships were removing the drainage regulation from the code.
Do I think the building code needs to address it better? Absolutely. Do I think the legislature needs to give counties more authority over it and better authority in enforcement capabilities and ability to issue violations and fines? Yes. Do I think zoning should be in charge of filling that gap in the meantime? No.
Yeah, it's tough. I get calls constantly, but from people that are affected by what their neighbors do to their yard that impacts drainage, and it's tough to enforce.
I mean, I've seen it, and I'm in no way, shape, or form suggesting this for the township, but I've seen it in property maintenance codes, but very general. But like I said, the trend now is to remove it from zoning regulations for the reasons that Joe has stated.
And my predecessor tried to float the idea of a property maintenance code in this community, and it went over like a lead balloon.
I was there that night, unfortunately.
And I think rightfully so. I think people move to townships for a different experience, by and large.
All right, having moved most of this material to the chart, are there any issues with anything on here? Most of it is relocated. There's some additional uses specifically authorized as a permitted or conditional permit used by section 505. I mean, this is just clarification. Are there any concerns about any of the additional or removed language? I don't know if there's anything that's removed. It looks like it's relocated.
I have one. Section 608, the minimum floor area requirements. I understand that this section is being removed like in 3 different areas. Same thing, right? Minimum floor. I mean, at this point, our township is almost built out, and we have a look and feel to our township. I feel like by removing this, you're going to change the look and feel of what is built from here on out. I think we have, you know, people moved here because they like what we have, and then removing this, I feel like will change our township in any new development. I feel like it should stay. It's 608.
608.
Minimum floor area requirements.
In the rural, right? Just
Yeah.
is just specific to rural.
Well, but it's in every section.
Yeah.
So this is the first one.
Yeah, it appears in 6, 9, might just be 8. I mean, I can elaborate on why it's proposed.
I know why it's proposed. I just disagree. That's why I'm bringing it up in front of the lawyer.
So that's interesting that this whole section is removed. 606, 7, 8.
Driveways just got relocated in 607. That just got moved up. That's now 60311. 608 is gone, as currently written.
in your, let's see where you have.
Can we, do you recommend that we keep it or delete it? My preference is to keep it.
So you want to keep the minimum square footage requirement?
Yep. Is there harm in that?
I think my only concern with it is fair housing has become such a hot topic, and Delaware County is such a target for people going after that topic, that you're gonna paint a target on your back, and someone's gonna come in and I mean, you see this with like ADA stuff, where people just make it do nothing, but just go around and find communities that they think they can get a slam dunk lawsuit and get their name in the paper and make a stink of it. So
But I
if we don't
feel-
have it there, we don't have that target. So I'm just trying to remove it.
I understand that, but also part of this document is to fulfill our comprehensive plan and our vision for the township. And we've had this vision for decades.
Sure.
And we're almost built out, so why would we change it now when we have maybe 3 parcels left to develop? Those may develop different. I just feel the wrath of the residents when something comes in that isn't similar to what's already here.
And maybe there's middle ground where, like, for the PRDs, you keep it, I mean, you don't have to get rid of it every section.
Yeah, true.
We're just in the rural, so you're.
I will say, of these things, by and large, most of these are not an issue. Most people have no problem meeting these. The attached garage and it being 2 stalls is probably the one where I think you might start to see a change in what people are asking for. At the end of the day, I think it's more of just it's a risk balancing. I'm not sure there's a clear, yes, you can do it, no, you can't, or you should or shouldn't. I think it's just a risk tolerance.
That's exactly right. So Joe cited the concern, but if you feel it's important, knowing the potential risk, I'm comfortable keeping it in, if that's what you want.
I would just make it like here, I'd make it just 60412, just to have it follow the new structure, but that's a very easy change.
And
for me to
we
make.
discussed the 2-car garage a few years ago, and we discussed storage. There are many homes that people don't park in their garage because there's
True.
stuff in it. So if you get rid of the 2-car garage, where are they going to put their stuff? You know?
Yeah. Some of that in the PRDs is a function of the PRDs not letting them have accessory buildings.
Right, exactly.
So it all has to go in their garage, and then they can't park in their garage. So, yeah, I mean, this isn't a hill I think I need to, I'm not gonna stand on. If you feel like it's worth the risk, then absolutely we should keep it.
I'll defer to the other 2.
I might reformat it a little
Thoughts?
bit just to make the numbering and lettering work, but
Yeah.
the content itself will stay.
And it's not like we're going and adding this, it's been there.
It's already
Correct,
there.
so, correct.
So it's not like we're going, oh, well, we're gonna add this real fast, so this doesn't
Correct,
happen.
so, yeah, you won't have that optic to deal with, correct?
I'm okay with leaving the square footage in there.
Do we want to do that for every article then? 6, 8, and 9? Or do you want to just talk
Or
about it?
do we
as
wanna
you go through
tackle it when we come to it? Why don't we
Yeah.
tackle it when we
Sure.
come to it?
So here, I'll just make it 60312, and like I said, I'll work the formatting so it just makes sense.
Okay. I don't have anything additional with Article
I don't either.
6.
No, I don't either.
Yeah, I'm not opposed to it. If you want to swear in, stand up, raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth to help you God. Thank you. Come on up and give your name and address, please.
Hi, my name is Courtney Phillip. My address is 8379 Hickory Avenue. I live in a rural residential district, and I'm not sure, Renee was just talking about the vision that you have for the township, but for those that live in rural residential, a lot of us, especially younger people like myself, millennials, we have the vision of going back to a more rural lifestyle, even if we don't live on the 5-acre tracts that, you know, by law, you can't really make all these restrictions on. I myself, I live on 2 tracts that total over an acre, but they're considered separate, even though they're adjacent. And so that puts a large restriction on what I can do in my property. And in the area that I live in, it's an older neighborhood. My house was built in the 60s. A lot of us own adjacent properties that total more than an acre. Part of the reason is once you combine them, we can't uncombine them based on the restrictions. And if something happens, you can sell off a parcel rather than lose your home. A lot of us want to be able to practice more rural things like, you know, agriculture, small livestock, things of that nature. And I don't feel that the zoning regulations leave room for that. We have a lot of, you know, HOAs, planned residential, but if you're in the rural district, I feel like we need a little more breathing room. I also live in the Hoover overlay, and it's kind of the same thing. My goal is to do things to, you know, conserve the wildlife, rejuvenate the soil, protect the water. There's a lot of things that I want to do that I feel like I can't do because, one, my 2 parcels are not considered to be over an acre, even though they're adjacent and they're owned by us. Even though if you look at the verbiage, if you're talking about parcels that total more than 5 acres, they can be combined. So I think the same thing, if you own adjacent properties, that should be considered. And in rural residential, we should be able to have a little more leeway if we want to have more agriculture, because I don't understand what's the difference then between rural residential and these other zoning areas. That was just kind of the main thing. Like I said, a lot of younger people like myself who are starting families are moving to these areas because we want that lifestyle. Obviously, we don't have the money to buy several acres here in Genoa Township, so I think there should be consideration taken into that. That's pretty much it.
Joe, you want to address her concerns?
Yeah, I'm actually very familiar with this situation.
Oh,
She was in
okay.
my office a few weeks ago. We talked about this exact same thing. So yeah, she's correct. The situation she has is a little unique where she owns 2 different lots adjacent to one another. With the way zoning's set up, we have to tell people, we have to enforce zoning on the per lot basis, regardless of ownership. So even though she owns the adjacent lot, there's still a lot line separating her lot from that lot. So I have to treat them as 2 different properties. So for ag, as we all know, ag's a wonderful topic to talk about when it comes to township zoning. If you're above, per state statute, if you're above 1 acre but less than 5, it's a very gray area of if-but-then scenarios of when you can do ag and what the townships can and cannot regulate, and platted lots and number lots, and it's very confusing, and it's all in Article 22. But if you're below 1 acre, the statute says we can restrict, if not prohibit, agriculture altogether. We don't prohibit ag on less than 1 acre, but we do significantly restrict it. So basically, it needs for your own personal enjoyment. If you have buildings with animals, they have to meet these huge setbacks. So I think what she's saying is either, what she's asking for you to do is either change the code, so in certain situations, we could treat both of her property as 1 parcel. I would advise that only doing that in limited circumstances. Like in her circumstance, it probably makes a little bit more sense. But in other circumstances, you might have a scenario where, like, if they ever sell that lot, it now becomes non-conforming because they don't own the lot anymore. So you got to be a little careful about that. The other thing is, are you more permissive about agriculture on lots less than 1 acre? And maybe you don't only do it for lots less than 1 acre in rural residential for the reasons stated by the public comments. So those are the things, like I said, I think it's 22 is the whole ag section. So we can either jump and talk about it now, or we can say, let's chew on it, and when we get to 22, we're gonna have some things to talk about.
Yeah, I think our goal this evening was to get through section 15 initially is what we had talked about. So I would say 22 would probably be better to talk about that a little bit later.
Yeah, and with that also, you know, consider if you do lean towards that, you know, agriculture, you know, the infrastructure that you need with it. Like, we're restricted on how many accessory buildings you have. So it's like, can you have, you know, a storage shed for your lawnmower, or can you have a chicken coop? It's you know, it's very limiting for us that want to actually do more agriculture. And again, maybe it is looked on by case, you know, based on the neighborhood. You know, I'm in between Sharmar and a horse farm. I mean, it's not like I'm living in the HOA in somebody's, you know, it's just a completely different environment, and I don't think that it's really looked like that. Because my big issue is, when they're building developments, everyone wants to scream about keep Genoa Township rural, keep it the way it used to be, but you're not letting the people do that in areas that want to do that. So I think we need to decide what we want to be as a community and stick to that. And, you know, we do have different places, and let people do what they're zoned to do. So that's pretty much how I feel.
No, that's a great point.
Good.
Yeah.
Thank
Thank
you
you very
for your
much.
feedback.
Appreciate it.
Don't forget about it. The next section is the Hoover Watershed Overlay. I don't know that there is anything significant here. The uses, again, have all been moved to the table. I don't know if there are any comments. I have no issues on here.
I think it just might be a typo. 701.013, should that be environments, or is that just like some special associated environs?
Environs is a word.
It is a word?
Yep.
It's like the surrounding, right?
Yep.
Oh, okay. Cool. I learned a new word tonight.
Very good.
I thought maybe you was trying to throw something in there for us to see if we were really reading it.
No, I'm
Yeah.
glad you're looking at that kind of stuff, though, because that's the kind of stuff we need to catch, too.
So, no, that was the only thing I had in there.
70310A4. I think the last time we updated this, or maybe it was a while ago, that we required an easement for a walking path. I'd like to take it one step further and require developers to build it. Or, did we talk about this? Put money in a fund, but I don't think we're allowed to do that.
Yeah, I'd prefer we not
Yeah,
do that, because I think we actually, we used to do that kind of stuff and got told, stop doing that.
okay. But I'd like to see the path built. I mean, if that would have been done years ago, we would have a lot of walking paths in this community
Absolutely.
And be more
along the
connected.
main roads. And I would like to see not only an easement be given, but also to build a path.
I'm all for making them do the sidewalks and the paths. I wasn't sure it was gonna fly, and I can imagine some of the flack will catch for that, because most communities do when they institute that policy, but I'm all about pedestrian connectivity. And I know people talk about sidewalks and paths nowhere, and it may be the case for 20 years, but eventually they'll go somewhere.
Eventually, they go somewhere.
So I'll address this because I'm experienced this more than I like.
All right, shoot me down.
Columbus also requires a sidewalk, and if anybody pays any attention, they're literally all over the place. There's even some on Polaris Parkway that have been there for 10 years. The challenge is at least in Columbus, if you're on a corner, then you have to provide an ADA access at the corner, and you can't orphan an ADA access. So what happens is the developers end up putting ADA accesses on all four corners, if it's four. It's obvious if it's a T, there's two. But it opens up a lot of consequences that we may not anticipate. So for that reason, I'm not for requiring it. Columbus does have, you can buy into a waiver. It used to be $40 a front foot. It's now $400.
It's good to be a city.
So clearly nobody's doing it.
And I think that's why we came up with a quote, unquote, happy medium that we did with the easements, was because the hardest part often is the land
Yeah,
acquisition.
that's right, because you can't use eminent domain, I don't think, for,
No,
No,
as far as I know,
we
you can't.
cannot,
So that's why it is the way it is, because of some of those. the pushback we thought we'd get from the development community, because they always complain about it. But there are some logisticals. I wasn't familiar, I knew there had to be something with the ADA, because I've seen those conditions before, but I didn't know the specifics of it, so I'm glad you actually
Yeah.
detailed it.
All right. I tried.
You are saying, though, now you have to get a divergence for it, and your justification, we're telling you have to do these things as part of that divergence, though.
So just to show the absurdity, if you drive down Sankas, there are no sidewalks, but there's ADA ramps on all four corners,
Yeah.
going to nowhere.
Well, there's one on the corner of Plum and 3.
Yeah.
There's a
that's
crosswalk
because
there
it's
that
an
goes-
ODOT funded project,
Yeah,
probably, so.
There's,
yeah,
there's
that's-
crosswalks and everything there. So bizarre.
So you're okay with this language? I mean, you can always
Well,
deny the
no,
divergence.
but okay.
That's the
Okay.
point of the,
Brand new developments where you can master plan it all out, it makes sense. But it's hard to, I think, I don't sure you can parse the zoning out like that.
Okay.
I mean, maybe in PRD, because you're rarely gonna have a PRD that comes back and amends and triggers that standard. But even then, you could open yourself up to some oddities. But in commercial, you'll definitely run into that issue.
This is the section 2 and 808, the minimum floor area requirements.
So is that one we'll also want to retain?
Throwing it out there for the group.
you're in the section 8, right?
Yeah, 808.
Yeah. Yeah, I'm okay with that.
Yeah, I'm saying, I think it makes sense to leave it in.
Okay. We ready for 9? I don't think I had.
I don't have anything else in 8.
Ready for 9?
No, I have something.
right.
I know it takes me a minute to get
While
through
we're
here.
here.
I have 2 questions, it looks like, for Pete. Oh, it is section 910.03.
Oh, are we moving to 9?
Oh, I'm sorry.
No.
We're on 8?
We
Like
were, yeah, are we
still
ready
on-
to move from 8?
Oh, yeah, apparently I just kept going.
Okay, so ready to move to 9?
Yeah, I am ready.
Okay. Go ahead.
Well, I'm pretty far back in there. I didn't realize I got to the next section.
Okay, my first question is 90101A, why are we removing such developments shall be based upon a unified development plan conceived and carried out for the entire site? Is there concern over that?
And it reads, it's in the intent and purpose section, but it reads like a regulation, so to me that's confusing. And it's somewhat self-evident that you have to comply with.
You have to,
You wouldn't be doing the PRD if you
You'd have
weren't
a
doing the
development
development plan, so.
Okay.
Not terribly helpful language.
yeah, I got you. You've added section 7 under B, provide housing and limited neighborhood scale commercial activity that is generally consistent with the characteristics typical of a primarily residential neighborhood. Can you go address a little bit about the intent of commercial activity?
Yes, so in the use table, you'll see in very limited situations, there are certain small-scale commercial developments we might allow in PRD. Say they want to develop something, put a little coffee shop in front of the neighborhood. Primarily residents that we're going to walk. Is that something that would be the worst idea in the world? I don't think so. And the example I always use, even though they are technically not the same development, it functions the exact same, is the bank and dry cleaner at the front of my house.
Yeah.
That's what we're trying to do. That type of setup where you want to put in, and there's controlling language too. Number one, we're controlling what uses can go in there significantly. They're going to be neighborhood skills. You're not getting McDonald's drive-through, you're not getting Walmart. You're going to be small uses that are shops, little restaurants possibly, and then the size of them are going to be restricted, as well as how much of the PRD can be provided to them is also restricted. I know the provision's in here somewhere, because I noted it in the PDF. There's a provision that talks about how much of the PRD can be designated for that commercial. So it's just trying to, I don't want to say true mixed use, but I think maybe trying to bring the code a little bit into the 21st century, that the idea of commercial and residential shall never meet is getting a little antiquated, and I think there's a high demand for people in these neighborhoods. They want to be able to maybe walk to a local coffee shop or a local studio. But again, it's not going to be anything controlled. So that's why that's language, isn't it? It's just saying, oh, neighborhood scale. And purpose.
Do we define neighborhood scale commercial?
You know what, we actually might, so if we do, we talk about it in the copy.
I just don't want to open these PRDs up to, they start putting, and we have to be subjective on what we're going to allow as commercial.
No, the use table is very specific about what those uses.
Here it says, neighborhood scale commercial, pedestrian-friendly uses, developments and/or structures which are context-sensitive and do not exceed 25,000 gross square feet in size. It's located in the definitions with the.
Context sensitive is the plain or fancy way of saying it, you must match your surroundings. And that is a defined term, context sensitive, in Article 4. Yeah, I'm trying to, I thought we defined. Yep, so neighborhood scale commercial actually should be capitalized because it is a defined term in Article 4. It reads, oh, yeah, that is what she just read, I'm sorry. So, Now, just because it says 25,000 doesn't mean we're gonna allow it to go up to 25,000. There's gonna be other regulations that come into play. We just use that term, the 25,000, because technically you could have a neighborhood scale commercial development in a commercial district.
Right.
The PRD would further restrict that down to, and I'm looking for the provision where we talk about that.
I just don't want to open that up.
Is that new language?
Yeah.
The concept is new, yes.
And my recollection is, I have always heard that we tried it, it didn't work, so we've decided we're not going to allow it any longer. And that's why I believe it was in here and it was taken out.
I don't recall it being in here.
How did you get the stuff by Highland Lakes?
That's technically a separate parcel that's not part of Highland Lakes, I
Got
think.
it.
Or when they came in, I'd have to do the homework. Either it's a separate parcel, or when they came in and asked for the rezone, they asked to rezone that section to PRD and that section to commercial.
I'm trying to remember, it's been there for so long, which came first.
I don't know.
The bank and dry cleaner is zoned commercial business district.
Correct.
Its own commercial.
Yeah.
Yeah, it's not on PRD.
Got it.
I'm not sure we want to open up PRD to start have commercial activity. For that reason, I would not have that in here. I think this opens the developers up to all kinds of options for commercial.
Yeah, we would just have to change the table to remove all the non-residential uses. I'm just trying to find the language, because I don't think it's as impactful as maybe it's being thought of. I'm trying to track it down, because I know I have
I
it
mean,
in
I don't
here
think the
somewhere.
dry cleaner and the bank are impactful, but they make sense along Route 3. But we don't have any parcels.
Here we go, I
Yeah,
found it.
right. Well,
905.04.
and
Yep,
we don't have any other large parcels along Route 3. So I'm not sure we want that on Plum Road.
well, you wouldn't see it on Plum Road, because it would, yeah, just be, this would only apply to PRDs. This doesn't apply to any subdivisions or anything else. And you'd have to come in with that development plan, and they'd have to present that to the board.
So
To get that approval.
this gives you the flexibility, because you don't have a true mixed-use PD. So I'm not saying you're gonna get like an Evans Farm type development, but that was a huge lift, because Orange Township didn't have a mixed-use district. So that, when that went through, they actually had to rezone under a residential PD and a commercial PD. But I think that's kind of the thought process behind that language is, you know, you're predominantly focused on the residential component, but do you allow maybe a coffee shop or a bakery or something like that, maybe at the front, and then, you know, but that's really what that would allow you to do.
So,
If that language is not in there, which, again, you determine the uses, then you pull it out of the use table and strike that language from it if you just want pure residential with none of those things. But you would have that flexibility, right, as part of your review of a preliminary development plan to say, hey, this really isn't either a neighborhood scale or it's just too much. But again, if you completely don't even want to see that, then take it out.
I'm in favor of taking it out.
So 905.04 does have the provisions regulating it, so we could modify, I'm sorry, I'm just trying to
Give the
speak to
full
why it's
picture.
in there.
Give the full
the
full
context.
picture, yeah.
So, right now, it says such uses shall not comprise more than 10% of the PRD's net developable acreage, and it tells you how we are gonna calculate that. And then it says no non-residential type use building shall exceed 5,000 square feet in gross floor area. So, and we could modify those numbers, we could add standards to that. If there's anything that you feel like you would not be, that you would wanna control, we could regulate that to further stipulate that. You could add, and setbacks for some of them are, like the setbacks for non-residential then are covered under 90602. So that's
Yeah.
that's the safeguards that we've tried to put in place. Also, if it's a use that requires like special standards, you also have whatever standards in Article 17 are gonna apply on top of that.
And I think maybe to Renee's point earlier, I think the other thing you need to look at is we need to be practical. Do we see property in the township kind of doing that limited mixed use, or do we think that, given where the big parcels are located, that probably doesn't make sense to, from a developer standpoint to put?
Then why have it?
Right,
Why-
that's my point, right? So if,
No.
Yeah.
The alternative is, if we ever want to do it in the future, we could just do make a different zoning district. With different,
So
a
I
different style.
was on the zoning commission when we drafted the comprehensive plan in 2016, and we exhausted public input, and when we identified an area for mixed use, we almost got chased out of the township.
That was the first attempt at the comp plan before I got here, yes, but I know what you're talking about.
So for that reason, I would not support this.
So we want to strike that out.
I don't want to be chased out.
Do you want me to make all so that will have a slight waterfall effect through the document, because I'll have to go back just to the table, to the PRD column, and knock out any of the commercial uses, and I probably can strike that section from the intent, that verbiage that talks about commercial from the intent purpose section, because we won't need it.
I mean, I'm just speaking for me.
Yeah, I'm
I
in
don't want to open
agreement.
that opportunity up to developers to decide what kind of mixed use we're going to
We
have.
can always, if someone comes to us, we'll say, well, we'll have to figure it out.
So the same language is in here for the divergence for sidewalk, right? Multi-use path divergence to be warranted.
Yeah, we're consistent on that approach throughout.
Yeah, okay. No common access drives.
Yeah, I don't think they have any place in a PRD. It's just a way to
Yeah.
try to cram in a few additional
Yep,
lots.
yep, yep. Permitted uses are in the table. So dimensional requirements have been almost virtually removed.
They're in Article 4. I'd like to keep the minimum floor area.
Yeah, so that would be consistent with what we've talked about. I'd move that into 90504 that we just vacated with the old language.
Okay. Where's the separation of 11 feet? I get so much.
Oh, I do too, but I talked to him about that. We can't change it because it's in black. Correct, Joe? The 11 feet,
B2.
we can't move it in,
905.01 B2.
yeah, B2.
Mm-hmm.
11 feet. Well, we want to reconsider the 11 feet.
I'd like 12. 12 is better than 11.
I don't think so.
No?
No.
showing changes in that section, right?
Yeah, there are changes.
There are changes, so.
It's there's changes in the section.
I would like to, so you're saying that since there's change in that section, we can address that?
We can change it, okay.
I would like to further investigate that and see where that number comes from.
I thought it was fire code.
Yeah, I think that's the, well,
Right,
it gets
but
a
it
little
can be
tricky with the
more.
fire code, because you technically can have a building go down to 0 feet if you're
Yeah.
willing to do the walls.
Right, the wall, yeah.
So I think this is, 11 is the standard for when you don't want to do all that stuff, the minimum separation requirement. This all goes back to we've had this conversation for years, about the separation. We can change it, but every time you have a condo product come in, you're gonna have that conversation, and you're gonna have that debate. And it's gonna be up to, I guess, the board that just sits as to whether they're gonna grant the divergence. So I know people don't like the look. They're incredibly popular product type. I mean, we've got developments that had those units in and that went through planning, got zoning approval, got all their engineering approvals built and finished before some of our other traditional PRDs that started well before them ever finished. I just think I understand the character, and so again, I understand people don't like them, but we have numerous neighborhoods of them now, so I'm not sure the character argument's gonna hold as much, because to me, that box has already sort of been opened. And I think if you make it big, someone's gonna come with a divergence, and they're just gonna point to, they already have it, you can't argue character because it already exists all over the place. So, I don't know, I don't wanna call it precedent, but I think it just opens the door to a lot of conversations that we were trying to avoid, which is why I think we changed it to begin with, because it was just becoming very heated and just ugly. And they're not cheap. So I mean, like going to 12, I don't think is like gonna be anything that's gonna cause a lot of heartburn to the development community. Not that we're writing this just for them, but I think that's pretty defensible. But I think if you go to you start going up to 20, I think you're gonna have pushback. And I think that's harder to defend because of the existing, what's already been built. I don't know, Pete, do you have any further?
I think it's really a matter of how far you want to push the envelope. Is that going back to that risk tolerance? But
I have a question, it's a Pete question. It's on page 9-15. It's 910.03, I guess it's I. I'm not sure this paragraph belongs in here. Keep going, it's the next page. Right there, I.
This is the section about open space and HOAs. And then H talks about the homeowners association may lease common open space lands to any other qualified person or corporation for operation and maintenance. So this is like the Genoa Township Land Conservation. I guess that's not a lease, they bought the properties outright.
yeah, that
So this would be something different.
is a little strange.
This was a section I wasn't terribly familiar with whether or not even should be in here, to be honest. This whole HOA and open space section. So I didn't want to touch it too much.
I mean, I don't know if homeowners associations even, I don't know what that would mean, lease subject to approval of the transfer assignment.
Like, could they lease it to
Recorded.
a
No,
sports group?
that would just be giving them permission. I mean, I'm not sure it would be a.
But say.
I guess it could be.
Say the HOA says, well, we'll lease it to you, but we don't want to have to deal with all the maintenance of all the grass you're going to tear up, so now you are going to be responsible for maintenance. You're running it, you're maintaining it. We're their owner, but that's it.
I guess theoretically, yeah. I mean, do we
mean-
allow that type of thing to happen in our open space?
We sort of have this situation with,
At the gardens.
a little bit. I was thinking more Grand Oak.
Oh,
We own that park at Grand Oak out front, in front of Big Walnut, but we don't maintain, that, there was an agreement when that whole development went through. I don't want to call it a lease necessarily, but there's an agreement that basically Grand Oak takes care of it. But we're the property owner. Maybe with a utility tower. No,
well, we can leave it. I just wanted to bring it up.
use the HOA, typically the HOA.
Just like delete it, like why is it in here? But if it's,
Well,
no,
I think one of the benefits for keeping it in here is we know what's going on.
okay,
You
yeah,
know what I mean?
yeah,
So, but it is a little odd language. I don't disagree.
okay.
But if they're gonna transfer or give a lease or license, whatever the case may be, to a athletic association or whatever, that at least we have the knowledge of that.
Okay,
I mean, at the end of the day, we just wanna make sure the open space is being used appropriately and maintained appropriately.
I could see a scenario, not that they've asked to do this, but like we have the Genoa Township Land Conservation Association. Right now, when they maintain property, they buy it outright. They, like, if you go to the auditor site, they're listed as the owner. Theoretically, an HOA could say, we don't want to be in the open space operation maintenance business. GTLCA, it sounds like you're fit to do that. But maybe GTLCA says, yeah, we'll do it, but we don't want to own it for whatever reason. Could the HOA then lease the open space to LCA as part of the LCA park system or something? Again, hypothetical.
I mean, it's odd. I think there's probably all sorts of like funding issues.
Yeah, I don't know why anyone would do that, but
Yeah, so,
okay,
and document restrictions, you know, your covenants, your, whatever the case may be, declaration. I'd probably just keep it in there, that way, you know, if it happens or there's an issue, Joe can at least require the lease or whatever other agreement that's in place, so he knows what's going on.
Anything else?
yeah, I have one, go ahead. This is the last page, yeah, same thing, yes.
So I see this section 91202 quite a bit in my professional experience. But this is new to us, right? This combined.
correct. This
submittal?
concept is new to Genoa.
Right.
Yes.
And are we, I didn't go far enough to see if this is proposed for every planned district?
Yeah, there's different iterations
Yeah.
based on the type of district it is, but yes.
Okay. I'm not opposed to it under certain circumstances if they qualify. That simplifies it for both parties. But I'd like to consider it a little bit.
Yeah.
I don't know that the language is what I want to see, but I like the concept. I just want to make sure I'm comfortable with the language,
Yeah,
right?
yeah. We are making it not a requirement. We're
Yeah.
saying
Yeah.
this is a path you can choose if you want. Knowing that when you choose that path, now you've got to do the full bore engineering up front and absorb all those costs to do it. So big developer might, with the resources, might opt to go that direction. Smaller people, they might like to go that direction, then see what that's going to cost up front and
Yeah.
make a different decision. I'm sure you see that a lot.
Yes. Okay, ready for the next?
Yep.
11?
Yep, 11.
We're now under Article 11, which is Community Business District.
I have a Pete question in 1104.07, and this verbiage, I think, starts here and then goes throughout the document. The low-level noise, should we get more specific, or is low-level good enough?
Yeah, so most of the time, when it comes to, one of the reasons most townships regulate noise coming from commercial districts is because for statutory authority, outside of zoning only exists for property within areas of residential use. So you can set up noise resolution outside of zoning for areas zoned residential. Noise control for commercial, you have to address through your zoning resolution. So the language that is in there, the reasonable person standard is based upon a city of Columbus dog parking ordinance that was upheld by the Supreme Court. But it is probably more common to regulate commercial through decibel.
Right.
I think that's where you tip. Now, the problem in doing that is you got to have,
Decibel reader?
yep, and then there's you got to make sure it's calibrated, you got to have staff training.
Which
and
is
you do-
why I've never wanted to go that deep into it.
Right. So, let me give that some thought, because I think there's maybe a little more that we could probably do to clarify the standard. Because most of the noise resolutions in residential area define at least how far you have to be from the property line. But the reasonable person standard has been upheld. I think we probably just take a look at because we do have a noise resolution, right?
Yeah.
Yeah, I think, yeah, that's what I thought. So I think we maybe look at some of those standards in there and see how we can apply them to here. But in a traditional sense, mostly what you see with commercial is a decibel level reading.
Primarily what I was getting at here was like, every gas pump now talks to you. You know, they've got the little
plays the
video feeds and
news
stuff
and,
on
yeah.
them, and it's,
Mhm.
technically speaking, are they supposed to have it? I don't know, maybe not, but we've never really bothered to go after it, because it's like, they're ubiquitous now. So, but I don't need someone blasting it, and having it heard from residential neighborhoods. Same with the speakers that they have overhead with the music and stuff, like, I did not want to get real deep into regulating noise. I think you've heard me up here before saying that's not really something I'm comfortable with us getting into for the reasons Pete stated, because you gotta, if you do it by decibels, that's fine. We just have to know if we really get pushed to enforce it, it could be difficult, because we don't have the meter.
Yeah.
I'd have to send all my people to training, we'd have to get certified, then I don't even know who calibrates them and how you get it proved. Do I have to have the Secretary of State calibrate it? And then they're gonna question, well, what were the conditions when you used the decibel meter? Was it cloudy? Was it windy? It just introduced, to me, the practicalness of it is very difficult. It sounds like it should be very easy, but unless I think you have like a professional that does that,
Yeah.
you'd almost have to contract it out.
Yeah, so I think working with the language that Joe has in there and taking a peek at our residential noise resolution, I think we could probably clean it up just a little bit to make it enforceable, or more enforceable, if that's even a word. I don't know. But yeah.
Yeah, I mean, I'm fine with needing to clean it up. I just don't want to go too deep down the noise
Yeah,
rabbit hole.
I agree, but I wanted to ask the
Enforcement is an
question.
issue.
Yeah.
Okay, so we agree we're gonna
We'll rework that.
continue that discussion.
I'll work
Yeah.
with Pete on that. Yep.
all I have.
I don't have anything either.
I don't have anything
good?
else. Yep, I'm good there.
All right, we're on to 12, Planned Commercial District. The issue about water and wastewater has just been relocated. That's not a concern.
Bless you.
Was,
Let's go to 120307, because they've struck out the minimum square footage of 65,000 square feet, which has always been our code, and changed the language significantly. Let's talk about that.
Yeah, so that 65,000 has been the subject of a couple cases over the years. One of which did end up in a lawsuit. And we've tried to clean up over time. This was something that originally was proposed to just be retained, and when the commission looked at it, they actually thought, when they were going through Article 14 uses this approach to square footage regulation, and they liked that approach because they felt like not all sites are created equal. So this was a way to, I think, accommodate that. So that's what they've done here. And we did they had me do like a MIDI study of existing square footages all throughout the township to come up with the ratio that they came up with. I think that study was in many of the papers that I had emailed to you back in June when after we initiated the document. But that's where all that comes from. Again, I say this knowing that this is one of probably a couple standards that ends up affecting square footage of a building on a property. You're also going to be controlled by the impervious coverage percentages up in 120306. And then many of the uses in Article 17, especially when we get into retail and shopping centers, have different square footage thresholds and maximums. So just because this standard says you could get this amount of square footage on this lot, there's going to be other standards that say yes, but that number is lower here and here because of these reasons. The impervious surface coverage percentage, we don't allow and the uses actually control that too. So like we've broken down retail into like small, medium, and large. So there's going to be certain areas where you can only do small retail or medium retail or large. Now PCD is probably going to allow for the most intense of the shopping centers and retail because that's our only really commercial district. But again, we have provisions put into place. If you do want to do a large commercial center, there's going to be, just like Pete talked about with like the data centers, there's going to be a lot of stuff we're going to make them do if they want to go that big, they're going to have to do a lot in terms of how it's laid out, setbacks, parking flow, landscaping, a lot more than what we require now, for sure. Because right now we basically say, hey, if you're 75% pervious and as long as you're 65,000 square feet, go for it. I feel like there's going to be a vast improvement to that situation. I also don't know if we have a huge threat of 65,000 square feet in PCD anymore.
Yeah, I hear you.
In fact, we have many buildings in PCD that greatly exceed 65,000 square feet now. Kroger, Home Depot. In fact, all of that at shopping center if you count it all up together. I think that provision was in there when there was more of a threat of a specific big box retailer possibly coming that people did not want. And I don't believe that threat exists anymore. Not without significant redevelopment, anyway.
There, section 1204 has been completely removed. Can you expound on that a little bit? Required conditions for businesses.
Yeah, a lot of that language got moved to other places, just in, I was noticing in the districts that the flow of them in terms of what sections appear in what order wasn't always consistent. So now each zoning district has a section called district standards. In this section, or this article, it's 1206. So a lot of that got moved just to district standards. Again, if you're on the PDF version of the color code,
Yeah, I see that.
it gives you more specifics on that.
Okay, good. Okay.
I think it's just the 1207.02. You want to look at that verbiage as well? Because it's kind of the same thing as in Article 11.
Yeah.
Oh, the combined process. Yep.
Combined.
Yeah, admittedly, some of those numbers are just numbers that I had to just come up with what I thought was reasonable. So obviously, if the board thinks there's a different set of numbers that are reasonable, we'll put those in there.
All right, planned industrial district, Article 13. Same, restructuring the language for the minimum or maximum square footage. This language changes are not a lot different than the planned commercial.
Correct. It's
Yeah.
very similar. Just
Yeah,
the
yeah.
numbers are different
Yeah.
because it's just a different district.
I would like 1303.02. I'd like to take out to the greatest extent possible. I think that leaves too much unknown. I think that's kind of a given, but why are we giving developers leverage?
Where are you?
1303.02, the middle in the red, it says to the greatest
Oh,
extent
yeah.
possible. I'd like to see that taken out.
Yeah, that's not good. I just, all I was trying to do was make sure we didn't paint ourselves into a corner too much there, but I don't think there's a huge risk in not having that language.
Yeah.
Everybody okay with that?
Yeah, I mean, frankly, it's going to get reviewed by county engineer anyway, access points.
Yep.
Especially in an industrial district, but that's okay. I don't mind taking it out. All right, we already talked about the uses. Convergence on sidewalk, multi-purpose language is very similar to the other districts. And the restructuring actually is too.
We just have the noise control here again to,
Yeah.
that we're gonna,
Yeah, whatever he writes up.
Wherever
for
it is,
That
yeah.
will mimic throughout.
That's all I have.
Trustee McMurray, anything new? And
no, that's what I was double checking. No, don't have anything.
all right, that moves us on to 14, Planned Community Facilities District.
fly.
Oh, yeah, the
Oh, he's
flies.
still flying
Yeah, he
around?
was
Oh,
over there.
yeah, oh, yeah.
He's making the rounds.
All right, the only other last thing is 1407.02, just the one-step process.
Mhm.
That's all I have.
Okay. You good?
I'm good.
All right. Article 15, light industrial. Again, I don't know that there's anything here that's much different than the other districts. Uses have been moved to the table. District standards. Noise control again on this one.
Mhm.
Yeah, I don't have anything.
Yeah. And you don't have the provision in here for the combined plan.
No,
No?
no, it's not a planned district, so this would just be
Yep.
straight district.
All right, 16 and 17 have a lot, if you have a look through this. So for that reason, I'm going to make a motion to continue the hearing to a further date.
I have my list. I think I don't know if you saw it, I emailed out the dates
Yep.
on my list to you as well.
Yeah. Can you pull those up?
Oh, no, I didn't copy Paul
Ah,
Hunt that email, I don't
let's
think.
see. I have them somewhere.
I can read
Yeah,
it to you.
I've got it.
I mean, if you give me a date range you're looking at, I'll tell you what the dates are.
Give me
with
the
it.
date range, because I don't know what you have for yet.
I'll just start going down the list. I guess stop me when you want me to stop.
Let's see, let's wait a minute, let's hold off. So it's the 30th.
Yep, so he's,
How much time do you think each of you need?
I'm ready. I mean, I'm good.
I'm through 16. Let me see how far I was at 17.
I mean, 17 is probably the most.
That's the longest one, no doubt.
So that's going to take us.
Now, a lot of it repeats,
Yeah.
Yes,
but it is long.
yeah. I'm through 16, I am not
So
through
our
17.
regular meeting will be on the 12th of August, right?
Yep.
I mean, I could probably do it again next Wednesday. Same time. You in town?
Fortunately, next Wednesday is not available.
It's Monday, 8/4, Monday, 8/11,
That's not near enough time.
Monday, 8/18.
8/11.
So 8/11,
8/11.
Yeah,
August
8/11
11th.
was the zoning commission meeting, but they canceled because they didn't have any applications.
I can do that.
what time? 6:30, right?
6:30?
Yeah, I can make that happen.
All right,
It's middle school curriculum night, but that starts at 4.
okay.
So 8/11.
Okay, so I move to continue the meeting to August 11th at 6:30 PM in the Township Hall. Do I have a second?
Second.
Discussion? Having none, roll?
Roll call, trustee Vaughn,
Yes.
trustee McMurray,
Yes,
trustee Antonetts.
Yes. Having no further business, I move to adjourn the meeting at 8:56 PM. Do I have a second?
second.
All in favor?
Aye.
Aye.
Aye.